Good afternoon, everyone. Thank you for joining us today. For those who are here on time, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationship with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Non-Disclosure in Insurance Contracts. My name is Rachel. I am an associate with Mawingrai & Associates, and I will be your moderator for today's session. Before we start the talk, let me introduce the firm and what we do. Mawingrai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Mawingrai. Our able team today comprises of 33 lawyers and a support team of 31. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-size law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focusing on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office physically since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsels. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice for your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. We have two speakers today, Edwin and Kirba. Allow me to introduce our speakers. Edwin Raj is a senior associate in our dispute resolution department. His areas of practice include general litigation, defamation, commercial litigation, professional negligence and indemnity, strata disputes, employment matters, and intellectual property. Our second speaker is Kirbasyini Chandran, who is also a senior associate with our firm. Her areas of practice includes contractual and commercial disputes, strata management, personal injury, public liability, medical negligence, land reference proceedings, and also employment law disputes. Our talk points today will be on pre-contractual duties in insurance contract, proposal form, nature of insurance contract, the misrepresentation under the Contracts Act 1950, misrepresentation and non-disclosure under the Financial Services Act 1950, factors in determining non-disclosure, case laws, and the remedies. Our speakers will first explain on the talk points. We will then conclude with the Q&A session. If you have any questions, please type them in the Q&A box and our speakers will address them at the end of this talk. Kirba, over to you.
Thank you, Rachel. Good afternoon, everyone, and thank you very much for joining us today. Welcome to our afternoon talk today on non-disclosure in insurance contracts. Let me begin by grounding us in what an insurance contract really is. At its core, insurance is a contractual agreement between two parties, namely the insured and the insurer. And the insured party pays a sum of money called the premium in exchange for the insurer's promise to protect against certain future risk or losses. Now, typically, there are three critical phases to an insurance contract. First, there is a pre-contractual stage, which is when disclosures are made and the insurer assesses the risk. Next, we have the contractual stage, where the terms are agreed upon and formalized in the policy document. And finally, there is a post-contractual stage or period of cover, where the insurer's obligation to indemnify or provide cover against a specified loss commences. Now, this framework is important because the issue of non-disclosure, which is the focus of today's talk, usually arises at the pre-contractual stage, before the risk has even commenced. Now, what is or is not disclosed during this particular stage can later determine whether the insurer is obliged to honor the contract. Now, at the pre-contractual stage, the process usually begins with the customer filling in what we call a proposal form. This form is essentially an application for insurance. It has a line of questions which the insured must answer, and the answers provided form the basis of the insurer's decision whether to take on the risk. This is a critical stage because the law imposes on the insured a duty of disclosure. So it's not enough to simply answer the questions asked. The insured must also disclose any additional material facts which might affect the insurer's judgment. Now, this is because the insurer knows nothing about the risk while the insured knows everything, and that imbalance makes disclosure very essential. The insurer will then review the proposal and may request further supporting documents. So, for example, in a medical report in life insurance or proof of income, or even a company search in commercial cases. Now, all of this information allows the insurer to then properly assess the risk. Based on these disclosures, the insurer will then decide whether to accept the application, decline it, or impose additional terms such as exclusions or higher premiums. So it's at that particular pre-contractual stage before the contract is even formed that most disputes about non-disclosure arise. So if the insured fails to disclose a material fact here, then the insurer may later on argue that the policy is void or that the claim should be repudiated. Okay, and then once the insurer has reviewed the proposal and decided to accept the risk, the transaction then moves into the contractual stage. Now, at this point, the insurer issues the policy and the insured agrees to pay the premium. The policy document is critical because it formally records the terms of the contract and it sets out the rights and duties of both parties as well as the specific risks covered, exclusions, and any conditions that may apply. For example, insurance policy might cover accidental damage, but exclude accidents arising from driving under the influence of alcohol. Now, once the policy is issued and the terms are set out in black and white, that takes us to the commencement of risk, which is the point where the contract comes alive and coverage starts operating. Now, at this stage, the insurance contract actually comes into effect, in essence. So coverage begins from the effective date stated in the policy, and that from that point onwards, the insured is entitled to protection provided that they continue to comply with the terms of the contract and keep up with the payment of premiums. For the insurer, this means that once the insured event occurs, for example, an accident, a fire, or a medical negligence claim, they are contractually bound to provide coverage. Now, if the insurer wishes to deny coverage, it can only be on proper and legitimate grounds. It could be causes things like claims which fall within an exclusion clause, or because the insured has breached the term of the contract, or misrepresentation or non-disclosure at the pre-contractual stage, which is what we will be covering today. That's why the earlier stage of the insurance in an insurance transaction is very important. So what happens at the proposal stage and what is recorded in the contract directly determines whether coverage will be honored when risk materializes. The key document, as I have mentioned earlier, at this pre-contractual stage is the proposal form, which you can see here. So on the surface, it looks like a standard application form asking for personal particulars, such as name, age, occupation, medical history, marital status, and so on. But in law, this particular form carries great significance. Now, the answers provided here together with any additional information disclosed, are what the insurer relies on to assess the risk and to decide whether to accept the proposal, and if so, on what terms. This is also where the insured's duty of disclosure comes into play. The insured is required to answer the questions truthfully and also to disclose any other material fact that could influence the insurer's judgment, even if the form does not specifically ask about it. So while the form may look like an administrative step, it is in actual fact the foundation of the contract, and many disputes of non-disclosure and misrepresentations can be traced back to what was or was not stated here. Now, most proposal forms also include a specific declaration or clause on representation, often at the end of the form. And this is usually presented as a declaration by the insured. By signing this proposal form, the insured confirms three things. First, that all the information they have provided is true, correct, and complete. Second, that they understand that they have a duty of disclosure, or in other words, they cannot withhold any material fact that might affect the insurer's decision. And third, that they agree the insurer is entitled to rely on their answers when assessing the risk. And this is a sample declaration which you'll find at the end of a proposal form. So it basically confirms that the insured's answers are true and complete, and that the insurer can rely on them as part of the contract, and that coverage only begins once the premium is paid and the policy is issued. For example, a few key lines from here, as we can see, is I or we, the proposed insurer, represent that the statements and answers in this part 1 of the application are written as made by me or us and are complete and true to the best of my knowledge and belief. So this is the core representation clause. And then we have the insurer's reliant clause, where it says here that they will be a part of the contract insurance if issued, and that I will be bound by such statements and answers, and that the company, believing them to be true, will rely and act upon them. So this highlights that the insurer is legally entitled to rely on what was declared in the particular form. So it directly links to the point that the false answers can void or affect the contract. Now, on the proposal form, there will also be a declaration on fraud. You can see just right below here, fraud warning. Any person who knowingly presents a false statement in an application for insurance may be guilty of a criminal offense and subject to penalties under state law. So again, it serves as a warning that if a person knowingly provides false information in an insurance application, it isn't just a contractual issue, but it can also amount to a criminal offense. Now, both of these declarations on representations and fraud brings us back to the bigger point, the absolute importance of honesty at the pre-contractual or proposal stage. This is simply because the insurer has no independent way of knowing the risk. They depend entirely on what the insured discloses. That is why full and accurate disclosure is absolutely critical, because it determines whether coverage will be granted at all, and if so, on what terms and what premium. For example, a person with a history of heart disease may still be offered coverage, but perhaps with a higher premium or with certain exclusions. Now, if the insured withholds or misstates information, then the insurer is making decisions based on an inaccurate picture of the risk. This is what leads to disputes about non-disclosure. This is also why the duty of utmost good faith has traditionally been considered the foundation of insurance law. So now, if information in the proposal form is not given honestly, or if the insured fails to disclose something material, that may amount to misrepresentation or non-disclosure. Now, it's important to remember that this duty applies at the pre-contractual stage itself, which is even before the policy is formally issued. So the law views these early statements as critical because they form the very basis of the insurer's decision. And the consequences of not stating accurate information can certainly be very serious. The insurer, as Edwin would explain later, may seek to void or repudiate the entire contract, treating as if the policy never existed from the beginning. Before we dive into misrepresentation and non-disclosure in specific, it's important to first understand the nature of insurance contracts themselves. Now, at their core, insurance contracts are simply agreements between two parties, as I've mentioned earlier, the insured and the insurer. And like any other contract, they are governed by the general principles of contract law. And in Malaysia, that means the Contracts Act 1950. So all the fundamental requirements of contract law, offer, acceptance, consideration, capacity to contract, and of course, the consent is free of misrepresentation or fraud are all present. And although insurance contracts are at their core contracts governed by the Contracts Act, they are also recognized as a unique species of contract. The Malaysian court in Malaysian Motor Insurance against Tirumaniar Singaravelul has emphasized that insurance contract of their own kind, sui generis. So this means that while contract law generally applies, insurance contracts are also subject to additional principles that are unique to insurance. This includes the doctrine of utmost good faith, the duty of disclosure, and rules on misrepresentation and non-disclosure. Beyond common law, they are also specifically regulated by statute, particularly the Financial Services Act 2013, and supplemented by principles developed through case laws. So again, when we discuss misrepresentation and non-disclosure in insurance contract, we are not just applying ordinary contract law, but looking at how these unique statutory and common law principles shape the insurer and insured relationship. I'll pass the floor to my colleague Edwin to take on misrepresentation and non-disclosure in detail.
Thanks, Kirba, for explaining the introduction on non-disclosure and the importance of disclosure in insurance contracts, as well as the nature of insurance contracts. Now, since insurance is in a form, it's a contract itself, before I speak into the specifics on insurance law and misrepresentation, allow me to just give you an overview or understanding of what misrepresentation is by applying general principles of law. So let's talk about misrepresentation. What essentially is misrepresentation under contract law? Misrepresentation is a false statement of fact that induces another to enter into a contract. Basically means a misrepresentation is a representation that is false, that influences another to enter into a contract. It simply means that. Misrepresentation is governed under Section 17 and 18 of the Contracts Act, and there are essentially three types of misrepresentation. Now, under contract law, you have fraudulent, negligent, and innocent misrepresentation. Now, in terms of what are the differences, mainly is the intention of parties, okay? The intention of the maker of the statement. So it's fraudulent when it's intentionally to deceive. That means when the maker of the statement gives a false statement intentionally, knowing that whatever that he makes in a statement is false, that itself is fraudulent. The deliberateness is there, present in fraudulent misrepresentation. Now, for negligent misrepresentation and innocent misrepresentation, it is not within the intention of the maker of the statement to make that false statement. For negligent misrepresentation, it is purely based on carelessness. The negligence here is that the maker of statement should have known that the statement is true, but unfortunately, due to carelessness, has made the false representation. Now, innocent, on the other hand, is no matter what, the party making the statement does not know that the statement is false, right? So if I give you an example, if sale and purchase of a TV. So if the seller does not know that this particular TV is actually model B, and only relies on the description of the model in the documents and all that, states that it's model A. Now, this particular person later on sells it to person B, and when he makes the representation, he says that this is model A, based on the description and everything, because as I bought it, this is what the description was telling me. If I make that statement, not knowing that it's not right, that it's actually model B, then it amounts to innocent misrepresentation. Now, in order to establish misrepresentation, there are 5 elements. There are 5 key elements, right? First, the false statement or representation of a fact. There must be 2 things, yeah? There must be a statement or representation of a fact, and number 2, it must be false. For example, things that do not include under this element is, for example, your weather forecast. Now, why is it not misrepresentation? Because it's a statement of opinion. Representation of opinion. In their assessment, the weather would be like this, it would be rainy or sunny. So it is not a representation of a positive fact. It's an opinion. So even if it turns out to be incorrect, you can't later sue them for negligent misrepresentation. Now, second element is that the statement must be made to another party. This is quite clear. It must be communicated. The statement must be communicated to another party. Now, the third and fourth element is interlinked, which is reliance must be placed on the statement made. Now, the reliance comes from the recipient of the statement. The person purchasing the product must rely on the maker of the statement. Let me give you an example. If A sells a car to B, and you imagine yourself, you are the purchaser of a car you want to use it for your daily use of transport, surely you would want to know the model, the condition of the car, right? So if A makes a statement such as that this car is of a particular model, I have only driven it for 2 years, it has not been involved in any major accident, surely there is particular reliance from the buyer because A is the present owner of the car. The second thing is that the statement must have induced the other party to enter into the contract. What this basically means is that it would have influenced the decision of the purchaser. So again, in that example, surely the model of the car, how many years it was driven, and whether the car was accident-free is something that would influence the decision of the buyer. So if it turns out later, it reveals that the car was actually driven by the owner for 5 years and there was a major accident that occurred in the car, then clearly this is misrepresentation. Now, the final element here is the other party suffers damage as a result. This is quite clear. So for example, in the example that I gave you just now, if B purchases the car and turns out that there was a major accident that occurred, B later suffers damages or costs in repairing the car. So if all these 5 elements are established, generally you would have a claim for misrepresentation. Now, the key issue here is silence. If I keep quiet about something, does that amount to misrepresentation? Now, under the normal general circumstances or the contractual provisions, generally silence does not amount to misrepresentation. So again, in the example that I gave, the analogy, if person B does not ask anything to person A about the condition of the car, how long it was driven, whether it was involved in any major accident, generally person A does not have to reveal those information, right? It is a buyer beware kind of situation. So B has to make that due diligence in asking those questions before it can amount to misrepresentation. However, as what Kirba has mentioned earlier, insurance contracts are slightly different. There is additional conditions imposed in insurance contracts because of the duty of utmost good faith. Okay, so in insurance contracts, silence can amount to misrepresentation in the form of a non-disclosure. Move on to non-disclosure and tell you why not revealing information or silence can amount to misrepresentation. Now, under insurance, specifically under insurance, misrepresentation and non-disclosure is governed under Section 129 and Schedule 9 of the Financial Services Act 2013. Now, in terms of non-disclosure during the pre-contractual stages of the insurance contract, everything is provided under Schedule 9. So if you read entirely Schedule 9, you will have an overview or brief overview of or understanding of what entails non-disclosure and the remedies that come with it. Now, before we move on to what is non-disclosure and the key principles or factors that determine what is non-disclosure, we first have to understand what is a consumer and non-consumer. Under the Financial Services Act, they have separated a consumer and a non-consumer. Why? Because the threshold of duty of disclosure is different for both. For non-consumers, it's higher. For consumers, it's much lower. Now, consumer under the Financial Services Act is loosely defined as any individual who purchases a policy for that individual reasons. Anything else, such as business or your professional policies, those all fall under non-consumer insurance contracts. So for example, if your company purchases a fire policy to guarantee in the case of an incident of a fire, those all fall under non-consumer contracts. Or if it's a marine insurance, non-consumer contract as well. Consumer contracts include such as your motor vehicle policies, your life insurance policies, and your medical policies. Now, for today's topic, I would only focus on consumer policies and particularly life insurance policies. But that doesn't mean that non-disclosure does not apply to non-consumer, but it's just for today's topic, I'll focus on consumer policies. Now, for consumer policies, it is the duty of disclosure is governed under paragraph 5 of Schedule 9. Let's dissect what paragraph 5 states. Before a consumer insurance contract is entered into, a licensed insurer may request a proposal. The proposal here is the consumer or the applicant for that policy to answer any specific questions that are relevant to the decision of the insurer, whether to accept the risk or not, and if to accept, what the rates are to be applied or the terms to be applied. Okay? The second part here is quite important as well. It is the duty of the consumer to take reasonable care not to make a misrepresentation to the licensed insurer when answering any questions under paragraph 1. That means it imposes a heavy duty on the consumer to take reasonable care not to make any misrepresentation. Now, you have an overview of what misrepresentation is, but I think you must be questioning what amounts to reasonable care and what amounts to relevant questions that are relevant to the decision of the insurer. We will explore that in a while. Now, these principles that have been laid out in the Financial Services Act were developed, the history of how it developed into the Act and how it was stated as such previously that I read to you. It was developed by an underlying principle called the principle of utmost good faith. This is the foundation of all insurance contract. Now, what do I mean by the principle of utmost good faith? In the case of Tanjing Jong against Allianz, the court has explained essentially what this principle means. It emphasizes that in an insurance contract, both the insurer and the insured have a duty to deal with each other in good faith and to make full disclosure of material facts. That means it must be good faith. It cannot be, I'm trying to hide something from you, I'm trying to get an advantage from you. No, it must come with good faith. You must disclose everything, and the insurer would take into account all your disclosure and give you a policy, either to accept the risk and give you a premium to be paid. Now, this duty is explained in detail in this case, Leong Kam Wei. Essentially, there are two parts, okay? It's not just the duty of the insured to disclose, but there's also a corresponding duty from the insurer. Now, first, let me go through what the duty of the insured is. On the part of the insured, he or she must make full disclosure of material facts. It is not for him or her to decide in his mind what is material. It does not matter whether the insurer asks any questions of the insured. The duty is on the insured to make full disclosure of material facts within his knowledge. That is upon a duty of the insured. That means you must disclose whatever that is relevant, okay, to the policy that you're taking. Now, what is the corresponding duty of the insurer? Okay, it's not just a one-way street, it's a two-way street. So for the insurers, their duty is to act promptly and in good faith when the insurer receives the claim. So when they accept the policy, when they issues the policy, immediately if there's a loss, when the insured here is the consumer, the applicant, when the applicant submits a claim, the duty or corresponding duty of the insurer is to assess the claim in good faith, okay, and to process the claim in a timely manner and in good faith. That means I can't be just headhunting for problems with your insurance contracts and try to repudiate the contract immediately. That is upon the duty of the insurer. Now that I've explained the background of the duties, the corresponding duty, let's move on more closely to what the principles of disclosure are. Essentially, in simple terms, what the doctrine provides and what the Act provides is that before you purchase an insurance policy, the insurer can ask you specific questions. They can ask you specific questions, and this is in a form, in the proposal form, like what Kirba has shown. They will ask you specific questions, and these questions are relevant. Why? Because they are relevant to the insurer to decide whether to give you, to accept risks or to provide coverage, and if yes, on what terms. Therefore, when the insured or the applicant answer those questions, they must take reasonable care and make sure the answers are true and not misleading and disclose important relevant information. Now, let's take a look at what are the factors that court decides in seeing whether there should be disclosure or whether the disclosure of the information is material or important or relevant to the insurer in deciding whether to accept risk or not. Essentially, in deciding whether there is reasonable care in disclosure, the court looks at three things. Now, when we talk about this, it mainly is disclosure on the insured. That means the applicant. The court will look at how it discloses. And the three factors that the court will look at are knowledge, materiality, and inducement. Okay? Knowledge, it simply means as whether the person has knowledge before making that statement. Of course, if I don't have that relevant information, how can I provide the information even if you ask me? Materiality is about relevance. How relevant is that information? Inducement is what I've explained to you earlier in misrepresentation. I will go into details of this later. Now, let's move to knowledge. The rule imposes a duty to disclose material facts that are known to the insured. Okay, disclosure duties only apply to facts within the insured's knowledge. For example, if it's not within my knowledge, I cannot be expected to disclose. Now, in determining whether that particular information that the insurer seeks is within your knowledge or not, the court takes a common sense approach. You cannot be expected to disclose what you genuinely don't know. But if it's something so obvious, significant, or recent, can you genuinely say that you are not aware of that information that you did not disclose? No, the courts will not accept a claim such as forgetfulness. For example, things like a major surgery. If it's a major surgery of your heart, that is something that you cannot just forget overnight. Okay, that is something that is within your knowledge, and the court does not accept that, oh, it happened 20 years ago, it happened 30 years ago. That's why I thought it was not relevant or within my knowledge. Let's move on to what then is genuinely, if I have no knowledge of the information. Now, it can be something that you have undiagnosed serious illness and no doctor has informed you. You have experienced no major symptoms in daily life, so you reasonably think you are healthy. You carry a condition from birth that has never been tested or revealed. For example, if you are born with asthma, but throughout the 20 years you are vigorous in exercise, you're an athlete, you're a sportsman, when you perform your activities, you do not have breathing problems. Breathing has never been an issue to you. You have never visited the doctor because of breathing issues. Here, when you apply for your policy, if they ask you, surely whether you have asthma or not, surely it's not within your knowledge that you have asthma. So you would definitely click no. But if subsequently you develop symptoms of asthma and it was found that you have asthma since birth, then that is genuine circumstances where you have no knowledge of that information. Then let's move on to forgetfulness and carelessness. These are scenarios where it is not genuine. You have no knowledge because of forgetfulness or carelessness cannot be attempts to convince the court that you did not disclose because it happened a long time ago or I was careless. Example that I just explained, forgetting something serious like a major surgery, being careless in filling out the form, okay? You can't just say, oh, I'm old, I can't see the clauses clearly, or I didn't bother reading the clauses carefully, the agent did not explain to me. Being careless is not a genuine attempt to say that I have no knowledge of serious information. Failing to exercise ordinary prudence. So something, for example, if you can easily check your records, that, oh, you have certain medical condition, then the court would not accept such arguments to say that it is not within your knowledge. Now, let's look at a case, Ulaganathan against Prudential. Now, this is a claim on a life insurance policy. Now, the deceased took a policy, and when the deceased died, the nominee, which is the plaintiff, submitted a death claim, but the insurer, Prudential, rejected the claim for non-disclosure. Now, what is the non-disclosure here? The non-disclosure here was that the deceased had previously undergone a splenectomy, which is the removal of the spleen, but failed to disclose this to the insurer. Can the insured now say that, oh, I have no knowledge of the removal of the spleen? What do you think? The issue was whether the deceased had undergone a splenectomy and whether he had knowledge prior to completion of the proposal form. Now, the court found that the deceased had known and undergone a splenectomy before completing the proposal form. Why? Because the medical officer testified in court to say that if someone had undergone a splenectomy, a major surgery, it is not something that he will forget overnight, even though it happened years and years ago. This is what the medical officer said. A splenectomy is a major operation conducted under general anesthetic and takes approximately 2 hours. Prior to splenectomy, the usual pre-operation fasting and pre-operation tests, CT scans and all that are required. There's also an operation scar. As a surgical scar wound after a splenectomy is relatively large, it will be quite painful. If one has a splenectomy, it is not something that he will forget, and after the patient has splenectomy, his immune system is jeopardized. It's a lot easier to fall sick later on, and preventive antibiotics vaccination will be given. So definitely such a major operation, it is not something that you will say that it happened long ago, I forget, or I was careless. Also, it is not just a one case scenario. Why? Because the medical officer testified that his immune system is jeopardized. So throughout his life after the removal of the splenectomy, he would have known, because he would be easier to fall sick and receive preventive antibiotics and taking regularly vaccines. So he should have known it is not a one single occurring event, it is a continuous occurring event. Let's look at another case. This is also involving life insurance policy. This is Chong Lai Keng against Prudential. Now, here is another claim on a life insurance policy that was rejected on the grounds of non-disclosure. Why? Now, the deceased intended to take 2 life insurance policies with Prudential, with each of the death benefit of 2 million ringgit. Okay, why there was a non-disclosure was the insurers found out that prior to applying for the 2 million policies, the deceased had actually already gotten 3 other life insurance policies with another insurer, AIA Berhad, totaling 3.5 million. The court said that this is not something you should leave out, or you definitely would have, in terms of knowledge. The court said that the proximity and the contemporaneous nature of the dates between the AIA and PMB policies, PMB is Prudential, okay, all were within a 2-month period. That means the deceased had taken all these AIA policies just shortly before he applied for the Prudential policies. So definitely it would be inconceivable for a person of sound mind to forget about the AIA policies, which had a substantial value of 3.5 million. Okay, the court said, given the significant sums at the stake and the proximity of dates, one would reasonably recall the 3 AIA policies purchased only a few weeks prior when applying for the Prudential Policy 1 and Prudential Policy 2. Taking into consideration the proximity and contemporaneous nature of the dates, it would have been inconceivable for a person of sound mind to overlook such substantial policies which had been recently applied for. Okay, that's all about knowledge. Now let's move on to a more, I would say, more relevant or important factor to look at when it comes to non-disclosure. Now, this is materiality and inducement. These are interrelated, so I will discuss this all together. Now, when it comes to whether an information is material or not, the court uses the word material. Material simply means relevant facts, right? Relevant information that the insurer would need to consider before accepting the policy or issuing the policy, accepting the risk, or determine the terms that would apply or the premium that would apply. Whatever information that is relevant to the insurer in making a decision, that is material. Inducement, of course, the insurer would be influenced differently. How the court will know is that if the insurer be influenced differently, if not for the non-disclosure. That means if I disclose something, the insurer would have not provided the policy, for example. That means it's so important that it influenced, the non-disclosure actually influenced me as the insurer, and I provided you the policy. Had I known that you had these certain conditions, I would have not provided that policy. So that is on part of inducement. It's like a 2-stage test. Okay, materiality deals with relevance in accepting risk and determining the premium. Was the fact one that a prudent insurer would want to know when deciding whether to accept the risk or fix the premium? Materiality deals with relevance. Inducement deals with causal link. Did the non-disclosure actually influence the insurer to enter into the contract on those terms? Materiality is about whether the fact is important or not. Inducement is about whether it actually made a difference. If it have made a difference, then it's inducement. Okay. Now, there are some circumstances that the court will take into consideration whether something is material or not. This is provided under paragraph 6, the duty to take reasonable care. I won't read out to you everything, but I'll just read out to you in short. The relevant circumstances would depend on a few things. The purpose of the insurance and the coverage, how clear the questions in the form are, and any expectation provided by the insurer. The purpose of the insurance and coverage, why are these relevant? For example, if you are taking up a marine insurance, surely the purpose is to protect your business in terms of risk when transportation occurs and all that. So definitely they won't be asking you to disclose about your habits, lifestyle habits, whether you're smoking, whether you have diabetes or not. Those are irrelevant because it is not aligned to the purpose of the insurance and coverage. Now let's go back to the 2 cases that we discussed earlier on knowledge. The same thing happened. The court also determined on whether the particular thing was material and whether there was inducement. Now, why there was an issue here was that the plaintiff or the nominee argued that the post-mortem report revealed that the deceased death was due to heart disease and fatty liver. So the plaintiff is saying that essentially whatever cause of death is different from the non-disclosure. Splenectomy, the removal of the spleen has nothing to do with the cause of death. So it is not important for me to reveal the fact that I have removed the spleen. The court rejected the argument, yeah? The court rejected the argument because of the two tests again. There must be two tests. It is not whether it is linked to the cause of death, but it is rather based on these two stages of test. First is that the relevance in determining whether to accept risk and determination of terms premium. The court said that accordingly, what are determined to be material facts are considered to be relevant. So definitely, you imagine yourself, if you're the insurer, you wouldn't know that what the cause of death of the insured would be in the future. But you would definitely want to know something major, such as a splenectomy has been done, the removal of spleen has been done or not, because then it gives you full information and whether to provide the insurance in the first place, and if yes, what are the premium. So although it's not related to the cause of death, it is still something relevant at the pre-contractual stage to determine whether to give that policy or not. Splenectomy is an important thing that the insurer considered because in court, they testified the fact that a patient has splenectomy, his immune system will be jeopardized. So that is something relevant to the insurers to decide whether to provide risk or not. Now, the second stage is about inducement. The insurer's representative state that had they known that the deceased had splenectomy, it would clearly increase the defense's insurance risk. Therefore, they would either have not entered into the insurance contract or they would have done so in different terms. This could mean imposing different terms or additional premiums. Now, the other case on Chong Lai Keng, whether there was materiality and inducement. Issue is whether the non-disclosure of the other policies is material or not. Remember, I talked about the purpose just now. It's relevant here. First stage in relevance in determining whether to accept the risk. Again, relevant, whether the information is relevant. Life insurance, the purpose of life insurance is not intended as a windfall and should not be utilized for unjust enrichment. That means the purpose of life insurance is to actually ensure that when the person who takes up the policy dies, the dependents would still have sufficient financial support as if the person who takes up the policy has been present and has been supporting the dependents. It is to cover financial loss stemming from the insured's death or inability to work, serving as a financial support mechanism for the insured or the beneficiary. That means it's not meant to be a windfall. Okay? If life insurance policies were meant as a windfall, we would definitely just purchase 10 or 20 life insurance policies. And if someone dies, the person would just gain 20, 30 million out of thin air. Okay? Such is not the case. So the court said in the first stage, in determining materiality, the important part is here. Life is not intended as a windfall, and the guidelines applied to an earning adult under the age of 50, that the maximum sum assured of death benefit should not surpass 25 times of their earned annual income. Okay, the deceased here earned an annual income of 150,000. And because he already had a coverage of 3.5 million in his 3 policies, issuing 2 other policies for 2 million would definitely surpass that guideline. Okay, therefore, those information are relevant. I'll move on to the second stage. Now, the testimonies of the insured was that these are material facts and it would have influenced the decision of the insurer. Why? Because had they known that he was already covered for 3.5 million under their guidelines, they would have issued the other 2 policies because then it would amount to a windfall, as I explained earlier. Just quickly run through examples of material information. For example, in your healthcare and medical history, material is something serious such as your prior diagnosis of diabetes or heart disease. Immaterial is something insignificant such as your childhood fever or chickenpox. Lifestyle habits, regular smoking, surely it will be material. Now, immaterial will be occasional drinking of low alcoholic drinks, beverages, or some only minor occasions. Okay. Occupation, for example, material works such as working in an offshore. This is high risk occupation. Immaterial office desk job with no usual hazards. Now, I'll show you this as an example. In a proposal form, they will ask, during the past 10 years, do you have high blood pressure, diabetes, stroke, and so on? They would also ask you, under 7, you will see, have you ever used controlled substances? These are all relevant information. Lifestyle is also part of the proposal. And finally, let's talk about remedies. What happens if non-disclosure or misrepresentation occurs? What can the insurer do? It depends on, like how I say, in terms of misrep, there's 3 points. There's fraud and deliberate, which is intentional. And then you have careless or innocent. If it's fraud or deliberate misrep, the insurer can avoid the contract entirely and refuse all claims, okay, even the premiums that you have paid. Now, if it's careless or innocent, it would depend. They can either avoid the contract and return the premium, or they can impose different terms. If they still want to accept the risk, they will probably impose different terms, or they can reduce the claim proportionally because they would have imposed a higher premium when you disclose those relevant information. Hence why if they would have known things, they would have increased the premium, and because they did not know, they would reduce the claim proportionally. But generally, in careless or innocent, they would still avoid the contract and return the premium. That's it. If there's any questions, I would pass the floor back to Rachel to ask any questions. Thank you.
Hi, Edwin. Thank you so much for sharing your insights. I believe we have a few questions from the floor. The first question, Kirba, would you like to take the first question?
Yes.
So the first question is from Lee. The question asks, if the insurer asked about past hospitalization, if the hospitalization is many years ago, as in when the person was very young, so obviously it's very hard to remember such hospitalization, how would you advise for the person to fill up the proposal form without being faulted for non-disclosure?
Okay, so when an insurer asks about past hospitalization, as Edwin explained earlier, as far as possible, the insured obviously has a duty to answer truthfully. Now, if the past or hospitalization is as a result of something that is quite significant or serious, then obviously you would not forget a fact like that. That is quite a critical fact of your life. So even if you cannot remember the nitty-gritty details of your entire hospital stay, you would still need to disclose things like, I was hospitalized for this many, not how many days, but during a particular year, details of which I cannot remember exactly, but there must be some disclosure as to the fact that you were hospitalized for something at a particular hospital. So it does not have to be to the dot accurate, but the disclosure must still be made, and you cannot leave that particular area requesting for that answer blank. That's the main thing.
Thank you, Kirba, for your answer. Our second question from the floor, I believe it's also quite similar to the first question. So the second question is, if the applicant had a history of cyst and underwent surgery sometime in year 2000, which is about 25 years ago, with no recurrence or related medical issues since then, to what extent is disclosure of this information required on an insurance application? So obviously the medical records in relation to this hospitalization would not have been available. So the applicant is asking, is there a time limit or guideline that determines whether such historical medical event must still be disclosed? Edwin, would you like to take this one?
Yeah, so as I explained earlier, it would all depends on the insurance policy and what the purpose of the insurance policy is. If, for example, it's on a life insurance policy or your medical insurance policies, then yes, remember the two-stage test, it will still depend on that, very much depend on that. Even though it has occurred a long time ago, what is relevant depends on the insurer. Okay, we cannot just take a guess on what we feel that is relevant or not. Usually it depends on the insurer itself, and the insurer would ask specific questions that would help the insured to understand what is relevant or not. So in terms of that, they would probably ask cyst or not. And it is also on the duty of the insured to just disclose if it's within your knowledge. There's no reason why you would hide an operation like that or removal of such cysts. If you're not sure whether it's important or not, and if you feel like it could be 50-50, it is better to disclose.
Thank you, Edwin, for your answer. I believe the answers which you have given just now have answered most of the questions from the floor. I believe if there are any further questions, we would invite the applicants to you can either address it in our website and we can fix a complimentary consultation for any further questions. But for now, looking at the time, we would have to end the talk soon. Before ending the talk, I would like to share a couple of updates. There are a few announcements. So firstly, we have an upcoming talk coming on the 3rd of September, the topic of which is Navigating the Skies, an overview of aviation law in Malaysia. So hopefully the attendees will be able to join us for this next talk. Secondly, we would like to ask you to fill in our feedback form and tell us what you thought about our talk. The link to the form will be posted in the chat box. Thirdly, do follow our social media accounts. We are on YouTube, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak with our lawyers, we offer a complimentary consultation up to 30 minutes over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.